All right, good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace and I'll be presiding over the two cases this morning. The first one we have is at 10 o'clock. Joining me on this panel are Judge Eric Eisnagel, and for the first time on our court as a district court judge, we want to welcome Judge Joseph Boatwright. We feel very privileged to have Judge Boatwright joining us on the court effective January 1, and welcome him to his first oral argument session as a district judge. I know he sat as an associate judge in the past, but welcome Judge Boatwright. And we have the case on the docket this morning at 10 a.m. I would just ask that the lawyers, when you're not doing your presentation, if you would please have your microphone muted and also mute any devices that may be in the background that may make noise so it doesn't distract from the presentation by the lawyers. I'm going to assume that Mr. Buhner, that you desire to have 5 minutes of rebuttal. Unless you tell me otherwise, we can adjust the clock. But other than that, I will allow you to begin your presentation. Welcome.
Thank you, Your Honor. May it please the court?
Yes.
My name is Stanley Bunner, and I represent the appellants in this matter, Jennifer Roller, Andrea Sule, and Kathleen Dowd. What the appellants are asking the court to do today is to reverse the order dismissing the amended complaint entered by the trial court below on count 1 of the amended complaint, and to require the appellee to serve a responsive pleading within 10 days of issuance of the court's mandate upon remand. There is a nominal defendant in the case, the successor trustee. That successor trustee has already filed an answer and affirmative defenses. Would the court benefit from a recitation of the facts, or are you comfortable with the facts?
I think we're familiar with the facts. If there's any important, especially important facts you'd like to highlight, that's fine, but otherwise.
Well, the amended and restated trust, the good news in this case is there's only one trust, so it's not confusing. We'll call it the trust. The amended and restated trust was executed on the 8th of August of 2013. 5 years later, approximately, on the 17th of April 2018, there were 3 co-borrowers who entered into an amended and restated master note renewal of loan obligation in the amount of $1,288,000. We'll call that the note. Again, there's only one note. Again, the important thing is there's 3 co-borrowers there: the settlor individually, the trust, and the settlor's widow, who is the appellee, Ms. Collins. They all 3 were co-borrowers on the note. Also, the trustee, in his capacity as trustee, executed a pledge.
What's the closest case on the issue of standing? What's the closest? It doesn't have to be an opinion. What's the closest legal authority you have to establish standing?
Your Honor, I would say it's the Genauer case that I cited in the brief.
Is that the one where the beneficiaries joined?
Correct. The successor trustee was defending a claim by the prior trustee's lawyers against the trust on fees issue. The successor trustee was defending it. The beneficiaries claimed to be the real parties in interest, and they wanted to assert their own defenses, and they wanted to participate. And in that case, it's a 2016 case out of the 4th District. The court said that they are the real parties in interest, and notwithstanding the fact that there is a representative who could do it under 1.200, they should be allowed to do it. And Genauer,
in the Genauer case, was there a lifetime beneficiary? I couldn't tell from the facts of that case. It appeared that both potential lifetime beneficiaries were dead. Is that correct?
I don't recall whether the lifetime beneficiaries were dead in Genauer, but I would agree that this was not an action involving a dispute between the lifetime beneficiary and the remainderment. That I would concede. Genauer followed the case of Berkey v. Lochner out of the 2nd District, which also said that the beneficiaries are the real parties in interest. And
Counsel, I mean, essentially, is your argument essentially that, look, you can't join without standing? So Genauer, if we're pronouncing that case name correctly, that case stands for the proposition that a beneficiary is standing because you're not going to be, if you don't have standing, you can't join the suit. Is that essentially what you're saying.
That would be the analogy there. And of course, there's St. Martin's Episcopal Church versus Prudential Base Securities that is also cited in there, where the court quite specifically said that they read 1-200 as not a limitation of who has standing to sue, but as an enlargement. It provides the ability of the trustee to sue on behalf of the beneficiaries. It doesn't preclude the beneficiaries from suing if they choose to do so.
Now, you agree that a contingent beneficiary obviously is more remote than the lifetime beneficiary, right? So where is that line drawn?
I would agree that a contingent beneficiary is more remote, but I would assert that these are not contingent beneficiaries. They are vested remaindermen. At the time of the settlor's death, they became vested remaindermen. And that is a crucial part of this.
Well, let me rephrase it then, counsel. They are more remote as well, correct?
I don't believe they're more remote. I don't know how you would say that.
How are they not more remote? Is it a guarantee that they will receive anything?
Nothing in life is guaranteed, Your Honor, but the trustee does have a duty to both the lifetime beneficiary and the vested remainder.
No, but I didn't ask if there was a duty to both. I asked if who's more remote. Your position is they are not more remote than the lifetime beneficiary. Their interest is not more remote. I'm not familiar with that legal doctrine saying remote. I mean, are they currently beneficiaries? Are you familiar with standing cases generally?
I am. Okay.
And you're not familiar with the idea of an interest that is too remote?
Correct. Yes. And a contingent beneficiary interest would be too remote. For example, during the lifetime of the settlor, a contingent beneficiary could not sue during the lifetime of the settlor. And I do point that out in my brief, that had this default occurred during the lifetime of the settlor, my clients would have no recourse. If the settlor—
Would a lifetime beneficiary sue during the life of the settlor?
No, everyone is remote.
So in that case, the two types of beneficiaries are the same, right?
From the perspective of do they have—
So what I'm asking actually is after the settlor's death.
Yes.
Now we have a lifetime beneficiary, right?
Yes.
And a remainderman. So I'm just simply asking you a pretty straightforward question. Which one is more remote?
Well, clearly Your Honor wants me to say
No, it's not what I want you to answer the question from your perspective. Is one of those beneficiaries, is the interest that they hold more remote, or are they equal in that regard?
I believe as a matter of law, they have equal interest. The timing is different. I would agree that the lifetime beneficiary's timing is more immediate than the remainder. Yes, I would concede that.
But your position is that does not make the interest more remote.
Again, I don't know what remote means, because I don't think there's any legal— I don't think there's anything of legal significance there.
We're talking about standing, counsel.
Correct. For standing, they clearly have standing. They're vested remaindermen. They have standing.
At some point, does someone's interest in a cause of action become so remote that the courts say that there is no standing? Is that—
Yes, and that is if they—
So that's counsel. You keep saying that you don't understand what I mean by the word when I say remote. That's what I'm talking about in the concept of standing. Which is
now I do understand. Now I do understand.
You do understand what I'm asking then, or no?
Yes, and I can't answer your question.
Please do.
I'm sorry. I really legitimately just didn't know what you were getting at. Yes, okay. In the Genauer case, in the Berkey case, the court explains that if a person has an ability to immediately directly benefit from an action, then they have standing. Their interest is not too remote to have standing, and that would be the case here. They have a direct— They will be directly affected. There has been damages here. There's been damages in the terms of a removal of $988,000 from the trust to pay for an asset that was never a trust asset, is not now a trust asset. The trust never stood to benefit whatsoever from this transaction in any way. And so they've been damaged, and clearly they will receive a direct benefit in the event that they are allowed to pursue the appellant for what is effectively the statutory action for the old common law claim for contribution on a note between co-makers, and therein lies their standing. And under— Does
a beneficiary of any kind always have standing to to sue anyone on behalf of the trust, or for instance, or on behalf of the trust assets? I mean, is there no line?
Well, there would be a line, and it's the line's based on whether or not they are vested or contingent, the nature of the cause of action. Sure, I'm sure we could come up with a hypothetical wherein the beneficiaries would not have the ability, they would not have standing. Yes, I'm sure they're yes.
I mean,
Counsel,
this-
when did the trust become the accommodation party under your theory? Was it at the time of signing the note and the pledge?
Yes, it becomes an accommodation party at the time of signing the note. Well, it's really the note. The pledge doesn't make an accommodation party. The pledge is obviously relevant, but it is not what makes it an accommodation party. What makes it an accommodation party is becoming a maker of the note, a co-maker along with the other two under subsection.
So while the trust was revocable?
While the trust was revocable, yes. But the significant time is when the trust became irrevocable, because nothing was drawn out of the trust. We don't know why the securities were pledged. It could have been simply to assuage the bank. Certainly, there's no allegations or any contention that the trust paid the mortgage while the settlor was alive. After the settlor died, it became irrevocable. And
Can a revocable trust, the way this is set up, become an accommodation party?
well, no, it couldn't become an accommodation party because the action to be an accommodation party would have to take place inter vivos. Again, I'm not challenging the inter vivos action. There was nothing inappropriate about making the trust an accommodation party. The question is, after the settlor died and the trust became irrevocable, what the court has to do is apply the statutes as they apply to the documents that he executed. He did not terminate the trust. He did not revoke the trust. He did not remove assets from the trust to pay this loan. Sure, he signed as an accommodation party, but the statutes allow the trust to recover from the other co-makers. I do notice, at least on my clock, that I'm down below 5 minutes, and I didn't want to exceed my time.
No, you've got about nine. The clock's on the top left counting, so you got nine and change.
Oh, okay. All right. Forgive the interruption. I will go back.
Counsel, how did Judith Collins become an accommodated party if she assumed liability and assumed personal responsibility for the loan as well?
Oh, Your Honor, as the statute says, that all makers, she stood to benefit from the transaction. She and the settlor both individually stood to benefit from the transaction.
I understand that she stood to benefit, but she also was assuming responsibility, which the statute identifying an accommodated party makes it sound like the accommodated party is not responsible or liable at all. And that's not the facts of this case.
Well, Your Honor, I don't read the statute that way at all, because an accommodated party has to sign. An accommodated party must be a co-maker. It must be a co-borrower. I don't read the statute at all to apply to someone, like, let's say that Ms. Collins never signed and only the settlor and the trust signed. She would not be an accommodated party under the statute, because the statute pertains only to co-makers.
Why not file a breach of trust action in this case? Why are you coming under Chapter 673?
My clients are not convinced that the trustee has breached the trust by not bringing the action. Reasonable minds can differ. My clients believe that they did have the ability under the law to move forward on their own independently, as the real parties in interest. And they chose not to pursue a breach of trust action against the trustee. Rather, they chose to pursue the action individually, collectively, but on behalf of the trust against Ms. Collins.
So refusing to recover almost $1 million is not arguably a breach of trust?
It could be, Your Honor. It could be a breach of trust, and then my clients may very well amend down the road. But at the initial time, they did not wish to sue the trustee for breach of trust.
I mean, essentially, this was your choice of action, and the action you chose was the accommodation statute, correct? I mean, essentially, that's the answer.
If you're asking if I personally made the decision, Your Honor,
well, no, I mean, no. I'm technically speaking, your clients made the decision. They get to choose their action, and this is the one they chose. That's what you're saying.
My clients determined at the time that they did not wish to sue the trustee for breach of trust at that time.
What's the distinction in your, trying to get the distinction you're making that if the securities had been liquidated and this debt had been paid during the settler's lifetime, you're saying that 673 wouldn't apply. Why does it apply now when it becomes irrevocable? What's the distinction?
The distinction is the settlor has passed, and we don't know what the settlor's intent is. If the default happened during the settlor's lifetime and he permitted the trust to be depleted to pay the loan, that is his right as a live settlor to.
Well, don't we know what his intent was? He pledged these assets. He didn't just pledge the assets, correct?
That's exactly the point, Your Honor. We don't know what his intent was. He very well may have only signed that pledge to satisfy collateral requirements of the bank. The bottom line is we don't know. However, even if he did intend.
Counsel, aren't we supposed to look at the document to determine intent here? We're not, are we supposed to attempt to look into the mind of the settlor here?
No, not at all, Your Honor. In fact, I'm asking you not to. That's what the other side's asking you to do. I'm telling you that
we do know his intent, right? We just read the trust.
Well, there's actually nothing in the trust that says that the trust is going to pay.
I'm just saying we don't attempt to decide to decipher what the settlor intended in his or her own mind. We look at the trust language, right?
That's a true statement.
And the trust language is there any question about what it says here?
There's no language in the trust itself that would impact the.
The trust doesn't indicate that the $1 million should go to pay for the default on the note, does it?
The trust does not say that.
Okay.
The pledge does. By pledging the assets, he effectively put the trust on the hook, and we're not contesting that was improper or anything. The fact of the matter is the statutes that apply after he died and after the trust became irrevocable, when the default occurred, they permit the trust to pursue what's effectively the statutory provision of the common law entitlement of contribution against the co-borrowers, especially under this and under the statute. Plainly, they can do it because the trust never stood to benefit from this transaction whatsoever.
You're in your rebuttal time.
Mr. Bunner, you're into your rebuttal time, so just
I will stop.
All right.
Thank you.
Thank you. All right, counsel, you may proceed.
May it please the court. Good morning. My name is Scott Weiss, and I have the pleasure of representing appellee Judith Collins in this matter. Obviously, the court is familiar with the facts, and the way we see it, that this appeal is based upon appellant's dissatisfaction with their father's pledging of the assets of his own revocable trust to guarantee repayment of this loan, the proceeds of which ultimately benefited the decedent himself and his spouse. Appellants believe that they have the right, in place of the successor trustee, to pursue an action and seek recovery from appellee, the decedent's surviving spouse, for some or all of the amount paid by the trust pursuant to the pledge agreement which the decedent signed.
Mr. Weiss, was the house in trust? Was
No.
the house, the title to the house in the trust?
The house was not in trust. The house was titled as tenants by the entireties.
Okay, so any benefit to the house or any benefit to the wife through the house, the beneficiaries, the contingent beneficiaries wouldn't receive any of that benefit, at least based upon the paper trail. Is that correct?
That's correct, but they're not challenging title to the house. They're not alleging that there was anything untoward with respect to how the house was titled.
I understand that, but the benefit to repairing the house, which is what it was supposed to be used entirely for, the contingent beneficiaries are not going to receive any of that benefit, correct?
They are not going to receive any of that benefit. That's correct. That's
Counsel,
correct.
where does the trust say that the $1 million should be used to pay the note?
The trust does not address that. However, I believe that the trust does generally contain a provision which says that the trustee is authorized to pay any debts of the decedent. And so what we could have had happen here, had this pledge agreement not existed, is we could have had Northern Trust coming and making a claim against the decedent's estate and or the decedent's trust for repayment of that obligation, which would have resulted in us being in exactly the same scenario that we are currently in, which is that the trust would have paid that amount necessary to satisfy the obligation on behalf of either the estate, if the estate was insufficient, or on behalf of the trust. And we would have exactly the same facts, which is that $1 million would have been paid out of the trust to satisfy this obligation. And and that's why we think that the accommodation party argument is simply invalid, because it doesn't take into account the fact that the parties here are really the same identity. If we look at the grantor of the trust, the decedent, and the trust itself, we're talking about basically a circle of the same exact parties. If the obligation had to be paid from the decedent's estate and the decedent's estate was insufficient, it would come from trust, exactly like what's happened under our fact pattern. And that's why we think that the accommodation party argument that the appellants are attempting to make is simply inapplicable here, because if we had third parties who were unrelated, I might have a different argument, but that's not what we have here. That's not the hand that we've been dealt.
Mr. Weiss, is that why you say in your brief that the grantor can't accommodate himself and therefore be liable to himself?
Exactly.
You can explain that a little bit more in light of a revocable trust.
Sure, I'd be happy to, Your Honor. So, a revocable trust is essentially, during the lifetime of the grantor, it's a legal fiction. It's an alter ego of the decedent. The decedent is the grantor of the trust, he's the beneficiary of the trust, and he's the trustee of the trust. He can't breach his fiduciary duty to himself. If he decides to take the assets of the trust and make an investment that is not a standard fiduciary investment, that's his prerogative, and he can do so. So he has no liability to himself for making a bad investment with trust assets during his lifetime. And essentially, we could draw the parallel that that's essentially what he did here. He signed
made an
this
investment
pledge
with trust assets.
Well, no, he signed
he
a pledge
didn't.
agreement.
Right.
Right,
It wasn't
he would make an investment.
Counsel, it wasn't an investment with trust assets, was it?
Right. No,
No.
it wasn't. No, it wasn't. But what he did was he obligated the trust to pay this loan back to Northern Trust. That's what he did. And he was free to do that. And they don't challenge that. The appellants don't challenge that. They're simply saying that, well, now after death, just because, regardless of the fact that he did it, he did it, but that doesn't mean that the appellee shouldn't be responsible, where she allegedly also signed the document and was benefited as a result of the payment. But, again, had Mr. Collins during his lifetime simply paid the obligation, we wouldn't be here.
But he did, but counsel, he didn't. He didn't. And during his lifetime, the trust was a different beast, right? It was
but he didn't.
It was
Yes,
a
he did. That's
different
correct.
animal. No, it was a different animal while he was alive.
That's
When
correct.
He died, it became revocable, right?
When he
And
died, it
never
became
said
irrevocable.
the trust. I'm sorry, right? You're correct. I got it backwards. He never said that the trust was going to make the investment, as you said initially. And I had to correct you. He didn't say that. That's not what happened.
No,
And
but he signed.
that would be a totally different case if he had said the trust is gonna make this investment. The trust is gonna pay this note. But that's not what the trust ever said.
No, the trust doesn't say that, Your Honor.
Correct.
But the trust does have a general.
The trust simply signed, right? Which looks an awful lot like the accommodation statute.
The trust, yes, he did sign the pledge agreement in both individually and as trustee.
Mm-hmm. And it wasn't an in-trust investment. The trust was never directed to actually pay the note. Why is it not? Explain to me again why it doesn't fit the accommodation statute. I'm just not following.
Okay, the reason that we believe that it doesn't fit the accommodation statute is that let's consider that the accommodation party, if the accommodation party were to take action for contribution or repayment, who are the parties that the accommodation party would sue? The accommodated parties being the appellee and also the decedent's estate. They would be joint and severally liable. And that's where we have this circular problem, because if the accommodation party were to sue the accommodated parties for reimbursement, then we would end up with the possibility that the accommodation party would have a judgment against the accommodated party being itself essentially the trust. So we're just basically chasing our tails here. And
isn't the trust, once it becomes irrevocable, isn't it an entirely separate entity by law?
Yes.
Right. So, I mean, essentially you have now a totally different party than the estate or the beneficiary here, the trust is irrevocable. It's an entirely separate legal entity now.
That's
And that's
correct.
the way the trust has it set up, right?
I agree. Yes.
Okay, so why? I guess I don't understand why that's chasing our tail. In your answer brief, you said that the argument is preposterous, and I'm struggling to see how it's preposterous.
Because the point is that if we look at what the result it would be, that's where the problem lies, in our opinion.
Why? Wait, no, let me stop you there. Why
Okay.
is the result preposterous, counsel? Perhaps the settlor only wanted the bank to be secure and to give them the loan. And so he had the trust sign on saying, hey, if we default, the trust will pay. But why is the settlor's intent here, as demonstrated by the trust language, simply that, hey, the trust isn't actually going to have to pay this. We're going to pay it, but the trust won't have to. The trust just signed so that the bank feels secure, right? If the settlor wanted the trust to pay it, why not just say that in the trust?
Well,
So I guess I just don't understand why it's chasing our tail, or why it doesn't make sense.
well, okay. I mean, from our perspective, the reason that we don't think that it makes sense is because if we look at what the substance is and what the legal effect of the actions are, he signed the pledge agreement. The trust may only have a general direction to pay legally enforceable debts, which this arguably would have been against his estate. But the fact that he signed the pledge agreement, that demonstrates his intent that the trust would be liable for the payment of this obligation. I mean, regardless of whether the trust specifically says it. I mean, we prepare trusts all the time, and we don't say in the trust, we don't put in a litany of obligations that the trust should be responsible for paying after the decedent passes away. I mean, that's simply not how we draft trusts. We generally put in a provision that says legally enforceable debts should be paid from the assets of the trust. And, here we have the decedent going and signing this pledge agreement, not only individually, but also specifically as trustee. And that puts the trust on the hook. And regardless of whether it's because the pledge agreement was enforced or not, if the pledge agreement weren't enforced hypothetically, and Northern Trust then decided not to, for whatever reason, use the pledge agreement and instead sue the decedent's estate, we would end up in exactly the same situation.
All right, counsel, you just did an effective job. I think I understand your argument a little better now. I'm not sure either way if I agree with it or not, but I think I understand what you're saying a little bit better now.
Okay.
Put it that way. Why don't you talk to us about standing?
Absolutely. Yeah. So, undoubtedly, the appellants are contingent beneficiaries of their father's trust, but they have no current right to receive distributions of trust assets during the appellee's lifetime. So the appellee is entitled to annual distributions of 6.5% of the value of the trust. And also she's entitled to discretionary distributions of principal and income as may be required for her health and medical care. And then upon appellee's death, if any assets remain in the trust, those remaining assets would be distributed to the appellants. Of course, sitting here presently, none of us know if there will be any assets remaining in the trust when appellants ultimately become entitled to distribution.
Mr. Weiss, but aren't the contingent beneficiaries, aren't they entitled to make sure or to have at least some protection to the trustee laying waste to the assets of the trust?
They do, but the way that those rights are enforced is by virtue of their receipt of accountings, which they are entitled to by law. They're entitled to receive an annual accounting, and then they're entitled to object to those accountings, and then they're entitled to have those objections heard. That's not what we were before the court on, but before the lower court. What we were before the lower court on was the contingent beneficiaries attempting to hopscotch over the trustee and try to basically bring an action that we think only the trustee would have the right to bring. And we don't think that they would have standing in their individual capacities.
Counsel, standing is a pretty sort of broad concept, right? And it's not always easy to apply. But why, when we look at cases like St. Martin's and the other case where there was a joinder in the attorney's fees case, I can't remember what the name of that one starts with G. Yeah. Those cases seem to lend some support Well, they seem to. And so you need to convince us that they don't, and explain why.
Sure, I'll be happy to try to do that, Judge. So the Genauer case, Genauer v. Downey, that's the fourth district case from 2016. And that's the case that my colleague argued that the beneficiaries are the real parties in interest, and they can therefore maintain a suit under that case. We think that that case is distinguishable. That case was about intervention. It was not a case where the beneficiaries were the ones who initially brought the suit. And they attempted to intervene in existing litigation that was brought by the law firm against the trustee. And then the trustee, I guess, countersued the law firm. And the beneficiaries in Genauer were not contingent at that point because they were entitled to distribution of trust assets at the time the action was brought. I think that Your Honor asked that question of my colleague and he didn't know the answer, but it was very clear in the Genauer case that both of the parents at issue had passed away. In fact, I noted that significantly in that case that it talked about upon the mother's death. It's right there on the second page of the case. The predecessor generation was gone. We don't have that in this case because we have, of course.
Let me stop you right there because I want to make sure I understand. Is it your position then that, for instance, the lifetime beneficiary could sue a third party, could skip the trustee and sue a third party in a situation like this, but the remainderman or a contingent beneficiary cannot? Is that what you're saying?
Under these facts, I believe so. And if I may explain my answer, I'd like to do so. Yes. And the reason for that is if the lifetime beneficiary could establish that they would directly benefit as a result of the action, then I think that absolutely they would have standing. In other words, under our facts, if my client identified a cause of action that the trustee was not willing to bring or did not bring, and it could result in a substantial recovery to the trust that would benefit her because there would be more assets in the trust available for her distribution, and her distribution is 6.5% of the trust value. So obviously, if there's more money in the trust, she will immediately receive an enhanced distribution. We don't have that in this case.
So this is a really interesting issue. Let me ask you this way then. What if you had a trust that it was absolutely impossible for the lifetime beneficiary to receive the entirety of the trust? The way it's drawn up, it's utterly impossible to do. Then would the contingent beneficiary or the remainderman would they have standing?
Well, I just want to clarify your question. You said remainder. Did you mean the remainder or did you mean the lifetime beneficiary?
No. What I'm saying is there's under this hypothetical that we're making up right now.
Yes.
That there is no way that the trust will be exhausted there's no way that the lifetime beneficiary will receive the entirety of the trust. It's drawn up in such a way that there is no doubt that the remainder there will be trust assets left. Okay. And no one can dispute that. Everyone agrees under this hypothetical that yes, the lifetime beneficiary will get a lot of the trust assets, but eventually, 30% of the trust assets or thereabouts will inevitably go to the remainder. In that case, would they all have standing, or would the lifetime beneficiary still be the only one with standing?
No, I think in that case, I think I would agree that all of the beneficiaries would have standing if the contingent beneficiaries could establish that they would benefit. I think that they all would have standing under that scenario.
So then the hard question then, and I mean, what you're saying, your answers make sense to me, but then the hard question is at what point does it become a fact question, right? That how likely or how likely is it that there will be trust assets left for the remainder? Or how unlikely is it, right? I mean, at what point, where is that line drawn? I mean, at what point does it become a fact question on just the issue of standing under this model that we're talking about?
Right. Under your model, I think, standing is always a threshold issue. I mean, why would we waste tens of thousands of dollars litigating an issue if there was no standing? I think that I would think that plaintiffs in that scenario under the model that you've posed, would have to have an affirmative obligation, an affirmative duty to establish that they would have standing, that they would benefit as a result of the action in order for the action to proceed. I think it would simply be unjust for, a defendant to have to defend something which ultimately, may be a hollow victory to plaintiffs who could never benefit from it. So I think that it's something that would have to be determined immediately. I mean, the only parallel I could really think of is under the probate code, where, in order to bring an action for removal of a personal representative or for revocation of probate of a will, that the beneficiary who's challenging that must prove that, that's a threshold issue. There's case law on that, extensive case law, that the beneficiary must prove that they're going to benefit as a result of either a revocation of probate or a removal of a personal representative. That's the closest parallel I can think of.
Mr. Weiss, now that this is irrevocable, does the trustee have the ability to recoup the funds from your client since she signed the note? I know you're saying in your motion for attorney's fees that her name was forged, but the trust does have that ability to seek that in this case, correct? If they wanted to?
I wouldn't dispute that. The trustee could file a lawsuit against my client should it seek to do that on whatever theory it would seek to do so. I mean, absolutely, the trustee can do whatever it wants to do, but the trustee has chosen not to do that for whatever reason.
Have anything further, Mr. Weiss?
Well, further, I think that I'd like to point out that the standing cases that have been cited, Genauer, St. Martin's, and Delaware v. Florida First National Bank are all distinguishable, because in those cases we have direct beneficiaries, the people who are right there in line to benefit from the trust at issue, bringing their grievances directly to the court. Whereas in this case, that's not what we have. We have contingent beneficiaries who are not certain to ever receive any assets from this trust, who are trying to basically jump over the lifetime beneficiary and bring an action in place of the trustee. And we simply
I have
don't
one more
believe
question, counsel, before your time expires. Are there any cases outside of Florida that support your position, your argument here that there's no standing?
I didn't look outside of Florida, Your Honor. So
Okay.
I don't know the answer to that.
Okay.
All right, Mr. Weiss, your
Thank
time
you.
has expired. Thank you. Mr. Bunner.
Respectfully, if I may briefly, I think the quandary that's being created here is the misuse of the term contingent. These beneficiaries are not contingent. They are vested remaindermen. They right now have both the lifetime tenant has a duty to not waste the trust, and the trustee has a duty not to waste.
How much of the trust assets will be left for the remainder?
There is no knowing. However, but let's say that the lifetime beneficiary were to take trust assets and light them on fire. Is she removed from the ability of the remainderman to sue her for waste because she could say, look, I could have gotten cancer and you could have gotten nothing anyway? It's a circular argument. These people are not contingent. They're
I'm
vested.
asking the same question, counsel. This is a perfect type of case, given the lack of development in the law to look outside the state of Florida, to look to other jurisdictions. Are there any cases outside of Florida, whether it be in the federal courts or another state, that support your position on standing?
I did not find them, Your Honor, and I can only presume it's because I believe the trial court was correct in that this is unusual, because I think 9 times out of 10, what the remainderman would have done is sue the trustee, or the trustee would have filed the lawsuit. And so it is unusual for the remainderman to be willing to bear the financial burden and to prosecute a case of this sort. So I haven't seen it. But the fact is that the plain language of the statutes apply to this dead on. They are not contingent beneficiaries at all. They are vested remaindermen with the present duties owed to them and the present ability to jump over. They stand to benefit directly to recover a portion of $988,000 that will go in this trust that will generate income that may eventually come to them. But the fact that they have no guarantee doesn't mean they're not damaged. I mean, you're transferring what are known under the law as vested remaindermen. You're turning them into contingent remaindermen, which they are not. They are vested. And Your Honor, respectfully, the plain language applies. As I said before, counsel was coming up with all kinds
So
of
you would say a contingent remainderman would not have standing.
A contingent remainderman would not have standing. They were contingent remaindermen before the death of the settlor. Everything the council told you about what might have been in his estate, what might have, for all we know, he had an insurance policy for $2 million that he wrote up on a piece of paper, pay the mortgage with this insurance policy. But instead that money went somewhere else. All that hypothetical stuff about what could have been, should have been is irrelevant. The fact of the matter is the plain language of the statute applies here. No one's
What about
demonstrated.
the trust? What about council's argument that the trust also says, hey, pay the estate's debts?
Well, first of all, I haven't seen that argued. I don't know the particular language in the trust that he's talking about. Typically speaking, well, that isn't the fact here. No one has come to the trustee and said, here, pay this debt. So it hasn't happened. So, I mean, I can't address that. I mean, a trust is required to do that. But again, we don't know that there aren't non-trust assets that would have been applied first in his estate. He's assuming it. He's saying, hey, there might have been, we don't know what the estate assets were. Also, his claim that there's joint and several liability between makers is false. That is not true. They need not sue all the different makers for contribution. And a trust is an independent person, both while he's alive and when he's dead. Certainly, it's far more important after he dies, but not. Respectfully, what the appellant is saying here, it's like being pulled over by a police officer for speeding and looking at the police officer and saying, I could have driven the speed limit, so don't write me a ticket. He didn't drive the speed limit. This settlor did not terminate his trust. He did not amend his trust. He did not use the trust funds while he was alive to pay this mortgage. He did not do any of those things. He passed away. The default happened. The statute applies on its face. There's no precedent saying it doesn't apply. And respectfully, we ask the court to apply the plain language. And as to that slippery slope argument, the court was clear in State versus Jet that is a question for the legislature. If the legislature didn't intend it to apply, then let the legislature amend the statute. There was no exception in the statute for inter vivos trusts after the settlor dies. And again, we're not challenging what he did in his lifetime. If the trust wasn't liable under the note, there'd clearly be no accommodation statute cause of action because there'd be no liability for the trust to have endured. It applies. Respectfully, we ask you to apply the plain language. I ask you to reverse the trial court's entry of the order dismissing with prejudice count 1 of the complaint and request that the court, upon remand, instruct the trial court to instruct the appellant to file an answer within 10 days.
Thank you, counsel. Well
Thank you.
argued case, and we will be in recess.